In this module, we discuss UCC Article 2, which is a special set of laws that provides some additional rules when it comes to contracts for the sale of goods. We just spent an entire module talking about contracts, right? You're probably sick of contracts and you want to move on to something else, right? Sorry, we're doing more contracts. Contracts are so important, and I've said this before. In this module, we are looking at a very specific type of contracts for the sale of goods. So when you sell somebody goods, we'll define that in a minute, there are different rules than if you sell somebody land or real estate, things like that. So in this lesson, we're going to introduce what we call UCC Article 2, which pertains to the sale of goods. And through the rest of the module, we're going to talk about some of the rules that UCC Article 2 puts on top of contracts for the sale of goods. So let's back up a minute. What is the UCC, or the Uniform Commercial Code? This is a set of statutes that has been adopted either in whole or in part in every state. Now, states aren't required to have adopted the Uniform Commercial Code, but many of them have. And the reason it exists is because a group of legal scholars and practitioners got together over 60 years ago and said, it would be really, really helpful if each state had some similar laws so that businesses that want to conduct business in more than one state have an easy way to know that things will pretty much be handled the same way as they cross state lines. Thus, the Uniform Commercial Code was born. Now, the UCC has a bunch of different articles. Article 2 pertains to the sale of goods. And that's what we're talking about in this lesson and the rest of the lessons in this module. So what is a good? A good is basically a tangible, movable thing. Cars are good. Pencils are good. Equipment are goods. Land, not a good. Buildings, not goods. I mean, some like a mobile home, that's a movable building. That could be a good. But a building that's affixed to land, not a good. Patents and trademarks, not goods. They're not tangible. Tangible, movable things are goods. And we have some special rules that we're going to apply to contracts for the sale of goods. Now, before we get into those rules, we have to make a very important distinction here. The distinction between goods and services. Because sometimes you'll have contracts that call for both goods and services, and you need to think, does UCC Article 2 apply to this contract? Because if it doesn't, then we just default to the common law rules that we learned about in the previous module, right? You know, agreement, consideration, capacity, legality, and writing, all that kind of stuff, all those rules still apply. The UCC just changes some of them a little bit. So if the UCC applies and it's a sale of goods, then we have to apply the new rules from the UCC. But if it doesn't, then we just go back to the old contract rules we've already learned about. So the way we decide if a contract that contains goods and services is governed by the UCC is by the predominant factor test. And the question is, what's the predominant factor of this contract? Are the goods predominant or are the services predominant? So for example, if I buy a new car and the car comes with a lifetime of free car washes, well, the car is a good, the car washes are a service. What's the predominant factor? In this case, the car is clearly the predominant factor. Would we buy a car without lifetime car washes? Sure. Would we buy lifetime car washes without a car? Probably not. So the goods are the predominant factor, and therefore UCC Article 2 applies to this contract. Another important term that we need to define as we move through our discussion of UCC Article 2 is what we call a merchant. Now, merchants are a special type of people under UCC Article 2, and special rules apply to transactions involving merchants. Now, a merchant is one of two things. Most commonly, a merchant is someone who deals in goods of the kind involved in that transaction. So you go to a car dealership to buy a car, the person selling you a car is a merchant of cars. Now, they're probably not a merchant of pencils, but they're a merchant of cars. They deal in that type of goods. So when you talk about a transaction involving a car, the car dealer is a merchant and has special rules they must follow. Another definition of merchants under UCC Article 2 is someone who holds him or herself out as having some knowledge or skill peculiar to a type of goods. So for instance, I love barbecue. I'm from Texas originally. If I created a website to spout all of my encyclopedic knowledge of barbecue, which by the way is extensive, I might hold myself out as being an expert in the realm of barbecue. That could qualify me as being a merchant in barbecue, even though I don't sell barbecue. I make it for my own personal use and my family and my friends, but I don't sell it. But if I hold myself out as an expert in barbecue, I could also qualify as being a merchant in barbecue.